Does the Equal Protection Clause of the 14th Amendment prohibit race-conscious affirmative action?
No, the Equal Protection Clause of the 14th Amendment does not prohibit race-conscious laws such as affirmative action when the intent of the law is to remedy past discrimination and to promote racial equality. First, the 14th Amendment states that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Second, the Congress that drafted and sent the 14th Amendment to the states to be ratified and added to the Constitution also passed race-conscious laws meant to remedy past segregation, such as the establishment of the Freedmen's Bureau following the end of the Civil War and the Civil Rights Acts of 1866 and 1875. Third, other laws relating to the federal government's interactions with Native American tribes were also race-conscious laws that demonstrate a clear understanding that the 14th Amendment was not meant to be colorblind and to prevent reference to race when the reason for that reference is to remedy past discrimination.
How does legislation enacted by Congress in the 1860s and 1870s affect your answer to question number one?
Legislation enacted by Congress in the 1860s and 1870s supports our reading because much of the legislation passed during this time was race conscious and was meant to remediate for slavery. The Civil Rights Act of 1866 guaranteed citizenship to all people born in the United States, no matter their race or history of enslavement or servitude. This, in turn, granted African Americans the rights guaranteed to American citizens. The Civil Rights Act of 1875 also guaranteed all citizens access to public facilities such as churches and theaters, which, due to the Civil Rights Act of 1866, now included African Americans. Congress during this time also established the Freedmen's Bureau, which provided aid and relief to recently freed African Americans in the South. In the arguments over the Freedmen's Bureau and other congressional legislation to foster racial equality, the framers assumed that the federal government was expected to respect equality of all persons as a matter of due process.
Okay. So let's assume that the framers of the 14th Amendment concluded that race-conscious legislation was constitutional in the 1860s and 1870s. Would that argument still work more than 150 years later in a very different society?
Yes, this argument would still work 150 years later because the 14th Amendment was not confined to only remedying discrimination against former slaves. The 14th Amendment extends to all races, and because race-conscious legislation was permissible in the 1870s, the 14th Amendment should likewise be applied in the same way today when race-conscious efforts such as affirmative action are meant to promote racial equality and remedy past discrimination of other kinds. In fact, this use of the 14th Amendment has happened somewhat recently in the United States. In 1988, Congress passed the Civil Liberties Act of 1988, which provided reparations to Japanese people and their families who had been jailed in internment camps following the attack on Pearl.
Okay. So let's assume that the framers of the 14th Amendment thought that people of African descent deserve certain race-conscious privileges due to the unique context of slavery. Would the framers have argued that members of other races, such as Hispanics, Asians, and Native Americans, could receive similar privileges?
Yes. When the 14th Amendment was first drafted, it only mentioned African Americans. However, the amendment was rewritten to not have any mention to any specific race before it was sent to be ratified. This shows that the amendment was designed to protect all races and not just Blacks. First, the legislative history from that Congress shows it covers more than just former slaves, but also Native Americans. As this court noted in Rice v. Cayetano, as we have established in a series of cases, Congress may fulfill its treaty obligations and its responsibilities to the Indian tribes by enacting legislation dedicated to their circumstances and needs. One example of this would be the Treaty of 1863. All of this history demonstrates that other races were meant to benefit from the 14th Amendment. Second, this court extended protection of the 14th Amendment to non-citizen Chinese workers in Yik Wo v. Hopkins in 1886. In this case, Yik Wo, a Chinese immigrant and citizen, was jailed in San Francisco for operating a laundromat without first receiving the consent of the Board of Supervisors of San Francisco. The law that he violated had made no racial classification. Yik Wo sued, and he argued that he was wrongfully jailed. The Supreme Court ruled in favor of Yik Wo, writing, "Though the law itself be fair on its face and impartial in appearance, yet if it is applied and administered by public authority with an evil eye and an unequal hand, so as to practically to make unjust and illegal discriminations between persons in similar circumstances, the denial of equal justice is still within the prohibition of the Constitution.
What would the framers of the 14th Amendment have thought about affirmative action policies that benefit people on the basis of sexual orientation or gender identity?
The framers of the 14th Amendment would have been in support of affirmative action policies that benefit people based on their sexual orientation or gender identity, because while these kinds of issues would not have been thought about during the writing of the amendment, the intent of the amendment is clearly to treat all people equally without regard to membership or behavior that have no bearing on a person's ability to participate in some activity or institution. Of course, the rights of women were expanded by the 19th Amendment and many civil rights laws in the 1970s to ensure equality and to remedy against past discrimination. Sex-based classifications still receive intermediate scrutiny by this court. An example of this court using intermediate scrutiny came in Craig v. Boren, which was the first case in the United States Supreme Court which determined that statutory or administrative sex-based classifications were subject to an intermediate standard of judicial review. So long as a sex-conscious law has the intent of ensuring equality and remedying against past discrimination, it would be keeping with the purpose and design of the 14th Amendment.
Does Brown v. Board of Education prohibit race-conscious affirmative action? In your answer, please address Bakke and Grutter.
So no, Brown versus Board of Education, which prohibited racial segregation in public schools, does not actually prohibit race-conscious affirmative action and doesn't restrict schools' rights to use race. While Brown overturned Plessy and prohibits separating different classes and denying school entry based on race, its actual purpose was to prevent segregation, which is inherently discriminatory. This ruling achieved racial integration, which is also the purpose of the North Carolina admission system. So supports our case instead of hurts it. So Brown did not find that the Constitution was colorblind. Instead, it concluded that separate is inherently unequal based on the separate schools that were being used at the time. And so the similarity is obvious between the racial integration presented in Brown and the racial integration that's achieved by the North Carolina admissions process. Brown aligns itself in views with our arguments of racial remediation and racial integration. Bakke, which found that race consciousness can exist if it is only a piece of the puzzle, which was found in the Bakke case, and which supports Brown's findings, and the idea that racial remediation can exist if it is used correctly, and has government interest as a result of that. This supports Brown's alignment with our case because it concludes that race consciousness can be used if it is used in a narrowly tailored format. Grutter concurs with this in 2004 about race-conscious affirmative action with Michigan Law School, which aligns with the spirit and the intentions of Brown in seeking integration throughout time and remedying past discrimination in admissions processes, as long as it is narrowly tailored and contributes to a compelling government interest. All three of these cases align with each other, and they all show Brown's aims to bring students together, which is incredibly similar to this case and the application of race presented here.
In 2003, Grutter observed that 25 years after this case, the use of racial preferences will no longer be necessary to further the interest approved today. Will there ever be a point in time in which racial preferences are no longer needed? If not, should the court allow racial preferences to go on forever?
The answer is yes. When Grutter created an expectation of 25 years for the achievement of academic diversity, the court created an estimate of the time based on the facts of that day and age, a time where there would be a critical mass of underrepresented students of every group in schools throughout the country. In the case of North Carolina, with its need to both take in-state students and to take other students for other reasons, financial aid or other programs, or just the way the students have lined up throughout the past 25 years, the educational interest of diversity has been slowly achieved and hasn't been achieved to the extent that a critical mass would be represented in our school yet. It is obvious based on the percentage of minorities that North Carolina is nowhere close to the government interest of complete diversity, but we will keep working towards using race as a tool to bring in diversity in each admissions year. Addressing the point in time where racial preferences are no longer needed, I can't speak to the exact point, but at some point in our society, we will not need a race-conscious program to reach appropriate diversity because it will already be reached, or the applications of each of the specific admissions program don't create diversity, or whatever the circumstances may be. But the court should evaluate when that point is reached based on the facts and circumstances of each case. Based on this case, the facts show that race is still needed to achieve diversity. And in the future, a different case, I don't know how far in the future, but a different case will have different facts that show that diversity has been achieved and race doesn't need to be considered anymore.
Okay, should Grutter v. Bollinger be overruled? Please address the Supreme Court's recent discussion of stare decisis in Dobbs v. Jackson Women's Health Organization.
So using stare decisis for a previous court decision to be overruled, evidence must be presented that first, the case in question was grievously wrong. Second, the case in question had negative consequences. And thirdly, that the case did not impact Reliance interests going forward. Under the stare decisis factors applied most recently in Dobbs, so the most recent application of these three stare decisis principles, Grutter should not be overruled. When the most recent overruling that this court had was Dobbs, and the Dobbs court discussed five modern factors that regard stare decisis and overturning precedents. Firstly, the nature of the court's error. Secondly, the quality of the reasoning. Thirdly, the workability of the rules imposed by the decision. Fourth, the disruptive effects on other areas of law. And fifth, the existence of concrete reliance interests. First, on the nature of the court's error, in Dobbs, the court found Roe to be far outside of the bounds of reasonable interpretation of the Constitution. However, in this case, we have shown that there's plenty of evidence that Congress intended to allow states to enact race-conscious laws, and indeed did it themselves. People could argue about what the history shows on the 14th Amendment, but you cannot complain that there is no interpretation for race consciousness within the 14th Amendment, because there have been years of evidence to show that under the 14th Amendment, race consciousness is intended and allowed. Secondly, on the quality of the reasoning factor in Dobbs, the court found that Roe firstly had no ground in constitutional text, history, or precedent, and that it imposed a detailed set of rules like a legislature might enact. So it's not as much of a decision as it is just a law. Here we have shown that there's significant evidence in the 14th Amendment, its history, its application in the legislation preceding and in the same time period as the 14th Amendment, that race-conscious laws may be enacted in limited circumstances to remedy past discrimination, for racial remediation, to lift groups into equality. Third, the workability of the rules. In Dobbs, the court found that the court overruled the Casey's court undue burden standard because it created confusion in their litigation. However, in our case, in the area of affirmative action in higher education, universities have been employing the standard of race-conscious admissions since 1974 and Baki's decision, which highlighted and emphasized where race consciousness can be used. However, there has been litigation over the years, and the court has clarified the application of strict scrutiny in Grutter, and the race-conscious principles have changed slightly. However, it's still very obvious that it's workable and usable in the real world to have universities that use race, and it's true that universities do use race. Fourthly, the effects on other areas of the law. In Dobbs, the court found that the Roe and Casey decisions distorted many other legal doctrines and created some legal issues in many sectors. That is not the case here. This court has recognized diversity as a compelling interest for years and years, and the decisions in this area have not impacted other areas of law because it's narrowly placed in higher education. And lastly, on the concrete reliance interest, in Dobbs, the court noted that the traditional interests arise where advanced planning of great precision is most obviously a necessity. However, that planning was not present in the abortion context. In this case, universities do have to conduct a lot of advanced planning to create a narrowly tailored affirmative action program and have relied on the standard this court set forth in Grutter to do so. For the past 25 years, universities have poured time and money into developing a workable, legal, and usable race-conscious admissions program that would help them work towards diversity fairly and equally. Schools have relied on this court's decision, and its reversal would damage those interests and damage those universities monetarily and in their programs, having to change their programs, having to change the way they do things. So for those reasons, the court should uphold Grutter under the factors of stare decisis.
If the court declines to overrule Grutter, can the plaintiffs prevail?
The petitioners can only prevail under Grutter if this court clearly concludes that the extensive factual findings of the district court were erroneous, or if this court concludes that the district court misapplied the Grutter standard and the facts of the case and decided wrongly. Here, the district court's findings were obviously correct. Race is one factor in admissions and is therefore narrowly tailored to seek racial diversity, which has been stated for years as a compelling government interest. This district court properly applied Grutter's standard to these facts, using Grutter as the best precedent available and the most recent application of race consciousness. It considered expert testimony and many other possible admission scenarios to determine whether North Carolina could have used something other than race as one of its many factors in its admission program. After considering all these alternatives, the district court found that the respondents' programs were narrowly tailored and complied with the Grutter standard. So if Grutter
If the court overrules Grutter, will the military have difficulty recruiting a diverse armed service?
The answer is yes. Over time, trends have been discovered in the military that indicate that the armed forces also favor Blacks and Hispanics over whites in their enlistment bonuses, educational benefits, and many other factors. In 2006, recruiting had helped the military improve to 15% of the armed forces being diverse in background and in race, as opposed to 7.5% in 1977. It's been better to have a more diverse armed service for this country as the years have gone on, and the military has changed recruiting and changed its process to try to include more underrepresented minorities to join into the military. Without being able to pursue diversity in the military will go back to what it was for most of the 20th century, which was overwhelmingly white in its officers and dominantly white in its other servicemen, because without the recruiting benefits and enlistment bonuses and the educational benefits that diverse soldiers received, the military will not be able to create a diverse armed service.